Okay, we are on the hour, so I think we will get going. I'm going to make a few introductory comments, so if people are joining while I say that, then they'll be ready and hopefully here by the time we get into the full content. First of all then, good day to you wherever you may be in the world. My name is Gordon Harris from the Gowling WLG International IP Leadership Team, and welcome to the second in our webinar series, The Lifecycle of a Smart Idea, taking a fresh look at the field of intellectual property by tracing the choices, options, and steps which can occur during the lifetime of a smart idea, from the moment of inspiration to the fulfillment of the business ambition. In our first webinar, we handled the question to patent or not to patent, and our international panel of speakers provided some insightful thought and guidance, looking at a range of the options available to an inventor or their company. If you missed the first one and would like to catch up, please go to goxl.gowlingwlg.com, where you can watch the full recording. This time, we're going to take a deeper dive into one of those options, the protection of an invention as a trade secret. In the first seminar, we identified some of the advantages of the trade secret route: no opening up of the invention to the whole world in a published document, lower cost, potentially, than a global patenting program, greater flexibility and access to criminal sanctions as improved trade secret protection measures are being enacted around the world. We're going to go a little further into some of the issues which have to be addressed if a trade secrets approach is going to be successful. And to guide you along the way, we have a multi-talented international panel of experts from a wide range of jurisdictions. So let me just take a moment to introduce our experienced and truly global panel. First up, from Canada, Chris Van Baar is a trial and appellate lawyer with over 2 decades of experience litigating complex IP cases. He was named Canadian IP Litigator of the Year in 2017 by MIP. Previously, he was Gowling's National Head of IP Litigation for Canada and was also an adjunct professor of IP law at the University of Ottawa, where he taught patents and trade secrets law. Also in Canada, we have Anita Nador, a partner in our Toronto office. She's a lawyer and patent and trademark agent servicing clients from research institutions and startups to large multinationals. She's recognized as a leader in her field by the world's top legal and IP rankings organizations, including IAM Strategy 300, the world's leading IP strategists. Anita's practice is focused on ensuring her clients' commercial interests and IP strategies are strongly aligned. In Paris, we have Céline Bay. Céline heads the intellectual property practice of Gowling WLG in Paris. She is a litigator and has been involved in huge cases across the full range of IP rights in Paris, acting for some of the world's best-known companies and brands, including the world's major tech companies. Céline is also well practiced in negotiating international technological partnership agreements. In London, we have John Ball, an experienced IP litigation partner. As well as handling a full range of contentious patent and trademark matters, John has been involved in a wide range of trade secrets cases in various sectors, from banking and finance through to oil and gas, including a number of cyber theft matters. John routinely provides clients with ongoing cyber and trade secrets risk management advice. In China, we have Ivy Liang. Ivy is one of the newest members of our team, having joined in April this year. Before joining us, she was a judge in the Guangdong Provincial Courts, and she served as Deputy Director of the IP Division, so she is fully up to date with all the recent developments in Chinese IP law, including trade secrets protection. And finally, from Moscow, Yulia Yanik is a partner in the office there. Her practice focuses on intellectual property and commercial law matters. Yulia has broad experience in advertising and marketing, media, e-commerce, and data protection matters. She assists clients in development of their trade secret strategy and drafting commercial secrecy regulations and NDAs. She was recognized as a next generation partner by Legal 500 in 2020. So today, I'm going to pose a series of questions to this great panel, sometimes to all of them and sometimes individually. And through that, we hope to give you a deeper understanding of the world of trade secrets and the early steps you need to take to establish a successful approach to trade secrets protection. We are looking to provide a global picture backed up by individual insights with some key jurisdictions. We start from the premise that the inventor or their company has made a conscious decision to adopt the approach of using trade secrets protection as the best means to ring-fence their invention and to give them a market advantage as it develops. On that basis, the first issue we want to consider is the adoption of a trade secrets policy so that the whole business can be aligned behind the agreed strategy. So question 1 is going to be initially asked to John Ball in London and then out to the other panelists. How should a company go about creating a trade secret strategy and what should it entail? John, over to you.
Thank you very much, Gordon. So if we're talking about setting a trade secret strategy and how we approach creating a trade secret strategy, the first step is to understand some basics, and in particular, the importance of trade secrets and their protection to the particular organization that we're dealing with, including how that may fit with the wider intellectual property protection strategy, notwithstanding that the company has identified that trade secrets may be key for it. Now, those that can vary quite dramatically between organizations and from sector to sector. Obviously, in some sectors like finance, trade secrets may be really all you have, whereas in others, patenting policy and patenting strategy is very, very important. So when you start setting what an appropriate strategy might be, you start with some of the bigger picture issues with questions like, where is the real value in our information? How much of it is likely to be published in any event via patenting or for regulatory reasons? Can confidentiality really work to protect the information in our business? Can we lock it down? Is it too easy to reverse engineer, for example? And also, very importantly, given the nature of the organization and its workforce, what is really achievable by way of keeping things confidential and secret? When you embark on looking into those issues, you can reach some pretty interesting findings with the organization around, where that value truly is, where does it sit, and also, of course, how much of it is ours and how much of it do we get from third parties. Based on that understanding of what the wider strategy should be, it's then about implementing that. And I think there are two key aspects of delivering on a strategy of that nature. One is what procedures, i.e. what practical steps are you going to implement to protect that information? For example, what technical security measures are you going to implement? What types of encryption are you going to mandate? What are you going to do by way of bringing personal devices into the workplace, restricting private email and other physical controls? And dovetailing with that, and very much part of the overall strategy, is what are the policies that the business is going to adopt and sign up to? Particularly, what are its employees signing up to by way of codes of conduct, compliance and training in order to implement those practical measures? And of course, what are the consequences of breaching those policies? So I think those are the two key practical measures to implement a strategy once you've developed it.
Thanks very much, John. Chris, over to you in Canada.
Thanks, Gordon. What I would do is focus on the foundation of the trade secret policy. And I think that companies should, at the get-go, sit down with their technical leads and identify their trade secrets. And I think you need to spend a good deal of time thinking about your manufacturing processes and your methods. People often overlook those as part of the trade secret. They often think of things and items, but processes and methods are important. They should then catalog what they have found and catalog it in a way that it can be used later in litigation as evidence that the company has identified the trade secret, determined that it is very valuable, and can show that they've taken careful measures to protect its secrecy.
Thanks very much, Chris. Let's cross the Atlantic then to Paris. Celine.
Yes, thank you, Gordon. I think that what Chris just said is really important. I wanted to emphasize a little bit because it applies to all jurisdictions, I guess. There are so many cases of fraudulent use of trade secrets before the French courts that cannot proceed just because of a failure to prove such fraud. So really the key words when we start talking about trade secrets are identification and evidence. Apart from that, I think that a trade secret strategy in a company implies to think globally. What I mean by that, I mean that once you have identified the trade secret, as we've discussed, you need to protect it properly, you need to protect it globally, meaning not only from outside, from competitors, but also from inside, as John said, from your own employees, to avoid uncontrolled disclosure, but also misappropriation once the employees leave the company. To avoid misappropriation, John talked about the procedures that can be implemented. To avoid uncontrolled disclosure, I think that the main thing in a company is really to raise awareness of the employees, of the importance of secrecy in the company. And the most effective ways to do that, I think there are two aspects. First one is internal communication. John talked about it, but I would like to emphasize on this, and also employment contracts. Internal communication, I mean, really companies should do presentations, trainings to their employees in order to explain what is secrecy, what is trade secret, and the consequences of a disclosure, really, to raise awareness. For example, of course, an invention that will not be patentable anymore if it has been disclosed, the loss of value of the assets of the company, the loss of value of the company itself, and also criminal prosecution, which is a good way also to draw attention. And then second aspect is the employment contract. Always recommended to include a provision on trade secrets. That's a good way to draw attention of the employees to that really important subject matter.
Thanks very much. So we're going to be coming back to some of those points later on criminal prosecution and also on the NDA aspect of employment contracts. So there we go. Right, for heading way out to the east now, and it's quite late evening in Guangzhou, so we're delighted that Ivy could join us from there. Ivy, what are your comments on this question?
Celine has given us a glimpse of the attitude of the French courts towards trade secrets. I will then introduce from the aspect of possible litigation in China. Well, we say that, of course, prevention is the best protection. A multi-dimensional strategy will give companies a blue sky to protect their trade secrets. However, first thing first, as John and Chris already mentioned about, the very step before creating a strategy is to sort out and anchor what kind of information, for example, technical information or client list in the company shall be protected as trade secrets. In the judicial practice of China, the trade secrets bear the name of the most difficult IP rights. Without well-prepared strategy, it is even difficult to prove the existence of the trade secrets in court. The doctrine of res ipsa loquitur does not apply here. That is to say, the bare existence of the said information itself would not grant you with protection as trade secrets. There are three major components we need to prove to court for trade secrets, namely the non-publicity, commercial value, as well as the adoption of confidentiality measures. Among them, the commercial value is often self-evident, and we as the plaintiffs do not need to prove the publicity. Therefore, the issue about proving of what kind and to which extent the confidentiality measures have been taken by plaintiffs always stand out. I want to talk about a little bit about my personal experience. When I was a judge, I ruled on a case which was the best demonstration on this point. In that case, the plaintiff claimed that one of the defendants, namely his former employee, copied his client list and competed for customers with this trade secret. However, the plaintiff failed to provide any evidence to support that it had taken any measures to protect this client list as these trade secrets. So much so that even the former employee did admit that he had actually made use of the client list. I had to dismiss the claim for the reason that there was no solid legal basis for the plaintiff. Let's see another situation. In the case of the pharmaceutical company Eli Lilly versus its employee, the court concluded that Eli Lilly had taken reasonable measures to protect its documents as trade secrets, and therefore ordered the employee to delete all 48 documents he downloaded from the server and prohibited him from disclosing and using any of the information in the documents. So the measures are so important in China too.
Thanks ever so much, Ivy. That's really comprehensive and very useful to get your personal experience from your judicial career. Right, finally then to Moscow and Yulia.
Thank you, Gordon. To protect trade secrets, Russian law requires that a regime of commercial secrecy is established, and that's both externally and internally. The owner of the trade secret should take the following measures, which are considered reasonably necessary. First, define a list of information which constitutes a trade secret. Second, limit access to and keep a record of persons who have access to such information. Third, regulate how the information can be used by employees and contractors, either in the employment contract or the service agreements, and have a detailed NDA with your business partners. And fourth, mark the information with a notice of confidentiality and identify its owner. It should always be remembered that the burden of proof would be on the owner of the trade secret, who would be required to show that the reasonably necessary measures were taken.
Thanks so very much, Yulia. And I think some of those practical points that are specific to Russia are actually of a much more general application as well, from what we're hearing and also personal experience. So finally, back to Canada and to round up with some general points. Anita, welcome.
Gordon, yeah, just to build on the points raised, when I think about developing a trade secret policy, I would emphasize 3 points. The first is, don't forget about third-party confidential information that you may have. It's very important not only to protect your own information, but also that of the third party. Also, you don't want to inadvertently incorporate that third-party information into your own IP, because it can get quite messy. Second is practicality, as John had mentioned. You want a policy that flows with your business, that doesn't hinder it. So as lawyers, we like to document everything, but sometimes there's situations where you may not need full PPE, where a simple face mask may do. For instance, if you're meeting with a vendor of office supplies that's not really core to your business, you may, setting up a clean room where you meet with outside vendors where there's no company information may be a good first start. Whereas if you're meeting with a collaborator or something of more importance, then obviously you would get other procedures in place. But last but not least is IP. I think of trade secrets as the rock of any IP policy, because if you think about it, most IP starts as confidential information. So as Celine had mentioned, in fact, confidentiality or novelty is a prerequisite for patentability. So when you think about it in this sense, what Chris had said with regard to documenting and making sure the company is aware of their information as it's developed through invention disclosures or other means, really is important. And I would say that you would also, which is very important, is to keep track of meetings and disclosures. I was recently involved in a case where in the middle of discoveries, it turned out that our client had a meeting with a third party prior to the relevant patent date. And you can just see that the other lawyer was sort of thinking, oh, he has his gotcha moment. But luckily, we were able to readily produce emails that showed, one, not only was the invention not disclosed at that meeting, but two, that all discussions were in confidence. So we're able to easily shut that down just because we had the proper documentation and we're able to move on.
Thanks very much, Anita. Don't go away because we're going to be back with you in just a moment. So thank you to the panel overall. We now know that we need an established trade secrets policy to be able to use this method of protection effectively. Now, one aspect of that, which has already been touched on by a couple of people, is a crucial issue, if policy is to be effective and viable, is the smart use of well-drafted and legally effective confidentiality or non-disclosure agreements. Of course, this is an area where national laws can be inconsistent, and we'll come to that with the panel. But first, I want to address the questions globally to Anita, who's an expert in transactional IP and contract drafting. So, Anita, there's a few parts to this question. Let me just run through them first. What are your most important tips for creating a truly effective NDA, one which stands a good chance of being enforced and helping to provide a strong wall around a valuable set of trade secrets? And then for the rest of the panel, how might those tips differ in your jurisdiction? And are there any absolutely vital issues which have to be addressed to meet local laws? So kicking off then with Anita, away you go.
Yeah, thanks again, Gordon. Obviously, enforceability is especially heightened. It's a heightened concern when it comes to trade secrets because once confidentiality is breached, it's hard to get that information back. So I see the purpose of an NDA as being sort of twofold. One is to clearly and reasonably define obligations so that each of the parties can take that agreement and know what they need to do operationally. So it goes back to John's points of practicality. But the second part of that is to assist the party claiming breach to establish the requirements for enforcement in the applicable jurisdiction. So in Canada, our Supreme Court has laid out a three-part test, which is fairly universal. The first part of the test is that the information conveyed was confidential. The second part is that it was communicated in confidence. And the third part, that it was misused by the party that it was communicated to. So in applying the above test, who the parties are is important. I think it was mentioned previously that about employees and them being perhaps a source of inadvertent disclosures. So that's something to be cognizant of, and that the courts will tend to treat contracts with employees differently than as between commercial parties. So it's important to know that difference. However, if I'm asked what the one thing is that is greatly enhance the enforceability of any NDA, and we review a lot, and it's oftentimes it's not necessarily readily apparent, and we usually have to put it in, is context. So, and this is especially so when people are working with template NDAs, they forget to put that in. And of course, we look at other parts of the contract, such as ownership of the information, the length of the duty and things like that. But adding context can, in my opinion, go a long way in drafting a contract that will be enforceable. It does not need to be a lot. One sentence can make a world of difference. Not only can it set out the consideration or quid pro quo necessary to enforce most contracts, it also provides clarity and specificity, which also enhances enforceability. So what I mean by context is defining why the parties are entering into the NDA. And it could be as easy as to assess whether or not to enter into a collaboration agreement for the development of drug X or insulin or whatever. And the more specific the context, the easier it is to enforce. So once I set out the context, then I can easily define the purpose of the information disclosures. And then the purpose, in turn, can help define what information is confidential. And that the information is being communicated in confidence. And if anything is used outside that purpose, it's misuse. So that goes a lot, just by adding context, can facilitate the enforcement of the agreement. And of course, last but not least, I look at the jurisdiction that's governing the contract. because as we will see by my colleagues, things can differ from jurisdiction to jurisdiction. And we're quite fortunate that I can easily rely on my colleagues and our associates around the world to ensure that we get a better NDA that's enforceable more universally.
Thanks very much, Anita. That's a really comprehensive and helpful answer. That's great. So let's fly straight off to one of those jurisdictions where things may be a little different. China. Ivy, what do you have to say?
Yeah, thanks, Gordon. Well, as Anita's tips are so concrete already, I will not go any further with this. However, I would like to raise your attention to the application of laws here in China. There's no independent trade secret legislation in China. The rules related to trade secrets are regulated mainly in anti-unfair competition law, and also separately in the civil law, criminal law, labor law, company law, etc. So as to the NDA agreements, different laws may be applicable to different types of NDAs. For example, if the company signs the NDA with employees, we may need to look at the labor law instead of anti-unfair competition law. It is worth mentioning that we need to pay special attention for the said NDA, for the reason that in China, the labor law policy assumes that employees are in a weaker position when signing the agreement with their employers. So the court may set aside some of the clauses in the NDA when it affirms that these clauses are not reasonable. However, I will talk about the exception for this exception is that when employees are from senior executive levels, the labor law may not be applicable to the NDA, and then the anti-unfair competition law as well as the company law shall step in. So the point to take away here is that the concept of NDA is quite spread out here in China. We need to evaluate the validity of the NDAs on a case-by-case basis and decide which law should be applicable to the present situation.
Thanks, Ivy. And the converse of that is obviously that if you're drafting an NDA, you're going to have to be thinking quite hard about the level of employee particularly you're dealing with, because it may need to be drafted differently into, from case to case, as you say. Okay, Yulia in Moscow, over to you.
Okay, thanks, Gordon. So what Anita has said is indeed universal and applies to Russia to the most extent. I would also echo Ivy's comment regarding the cases when the courts take the side of the employee and dismiss the employer's claim on the trade secret disclosure. In one of such disputes, the judge in Russia held that sending information by an employee to an external email, which was a personal email, was not a disclosure of the trade secret, as the information was not marked as confidential by the employer. So that means that even in the existence of a solid NDA or an NDA clause in the employment contract, its enforcement may be difficult, if at all possible, absent the implementation of the trade secret regime by its owner.
Thanks very much. That's great. Now, Paris, Celine.
I can give 3 tips to draft a proper NDA under French law. There are others, but my 3 recommended tips are these ones. First of all, there is no discovery proceedings under French law. So the proof must be given by the claimant at the very beginning of the case. You cannot start a litigation without having all the evidence. So when I draft an NDA, the first thing I ask my client is to provide me with an exhaustive list of documents, elements, really precise lists of what is the trade secret, what this NDA is about. It's a heavy work sometimes. Sometimes the clients are reluctant to do so, but in the end, at the end of the day, they can see the benefits. It's almost certain that you will be able to prove what you invoke before a judge if you do that from the very beginning. And of course, the list will be annexed to the NDA, to the contract, and it can evolve, it can be updated during the existence of the NDA. So this is the first thing. The second tip would be to draft a proper ownership clause, especially if the NDA is part of a joint venture or of a partnership agreement, where you might have some joint developments from confidential information that you gave as a company or your client gave. So under French law, we have standard provision regarding co-ownership that would apply if your NDA is silent, and that you wouldn't want sometimes that they apply. So it's really recommended to draft a proper clause and to exclude joint ownership as far as possible. The third tip I would give is think about a clause of intuitu personae, that is to say immediate termination of the NDA in the case of change of control, to avoid simply the acquisition of your trade secret by a competitor. That's really recommended under French law.
Thanks very much indeed. John in London, over to you.
So I don't think there's a huge amount I would add, particularly from the sort of common law perspective to what's been said before, particularly by Anita. Just a couple of points probably worth adding though is, from an English law perspective, certainty of contractual terms is very important when it comes to enforcement. So as well as things like, you know, some of the formalities under our law, having given consideration for the undertakings you're getting from the other party, we should also try and avoid perhaps open-ended or overly broad or uncertain NDA undertakings. For example, those that seek to capture all information even though it's clearly not confidential is one example of uncertainty. Our courts don't like uncertainty in contractual terms, and it doesn't make enforcement any easier. Over and above that, obviously one of the things that we mustn't forget is building in contractual clauses around what happens at the end, particularly around steps for return or destruction of information and that sort of thing.
Thanks very much, John. And finally on this one to Chris.
Gordon, focusing on enforcement, the breach of a non-disclosure agreement is often part of a suite of actions, causes of action that go into a breach of confidence case. You'll have contractual, breach of NDA, common law, breach of confidence, breach of fiduciary duty if it's a departing senior employee, perhaps statutory copyright. All of those are part of this larger action. But the NDA is a really unique opportunity, and I would pick up on context, which Anita and others mentioned. Because the NDA gives you the opportunity contractually with agreement from both parties to set out how they understood this information was to be treated at the time. It's the best contemporaneous evidence that you have. So you're not trying to cobble it up afterwards to demonstrate how important it was and how you were keeping it secret. It's all there. So a good NDA is very, very useful, very important tool in a breach of confidence case. And that context is also, it reveals itself in another way, which is that the judicial context is important. Breaches of confidence, breaches of NDA are all addressed locally. These are provincial court cases, not federal court cases. And so, I have to reach out to my colleagues in Calgary, Vancouver, other cities, and in particular Montreal, because the Quebec courts under the Civil Code treat breaches of confidence quite differently. And so that context, that judicial context is important. And then finally, just briefly skipping over the border, it's a good reminder to note that, that the US treats it very differently as well, or at least specifically in their own context. I can think of a couple of fairly recent district court cases where the NDA that the plaintiff was relying on was actually used to defeat the plaintiff's case because the NDA was time limited. The judge said, well, if you put such a short temporal limitation on the NDA, the information can't be very secret, can it? And so that was, a critical factor in that case and a good reminder to seek good US advice if the case is there.
Thanks very much, Chris. And overall, I think the advice clearly there is that you need to talk to people in the relevant countries, because there are nuances, there are little differences pretty much wherever you go in this field. Anyway, thanks to you all for that, and it's good to see that the language of Latin is not dead, at least in France and China. So our trade secrets policy is in place, and we have strong NDAs to back it up. Of course, the evolution of a smart idea to exploitation will almost always involve outside assistance. That might come from, say, a university department, or a joint venture partner, or a potential manufacturer. This might involve sharing the trade secrets in written form, drawings or whatever, or in a much more material way in terms of models, parts, or samples. A good NDA structure can go at least some of the way to protecting the trade secrets in these circumstances, but it may not do the whole job. So what other really practical steps can you take to protect valuable secrets when information has to be shared for the development, evolution, and ultimately manufacture of the protected item? So I'm going to start here in Russia with Yulia, but what practical steps would you take to protect the secrecy of your invention when you have to share material, software, drawings, etc., whether it's with a business partner, a development lab in a university, a JV partner for development of the concept, or a potential external manufacturer? Starting with you, Yulia.
Thanks, Gordon. So I would say that no matter who your business partner is, the types of measures which the owner of a trade secret should take are more or less the same and sit on the three levels: physical, IT, and contractual. On a physical level, it is important to restrict physical access to the trade secret information. Make sure that the documents and devices are properly marked as confidential and safely stored. I would also recommend avoiding intermediaries when, if possible, when transferring the information comprising a trade secret. On the IT level, the measures include setting passwords on computers, devices, and documents, blocking USB plugs, using encryption for the information transfers. Interestingly, with the pandemic and all of us working remotely, the IT measures are becoming more and more important when we share the information from different parts of the world. So the IT measures need to be taken very seriously. And of course, on a contractual level, we cannot reiterate enough that a solid NDA should be in place. And in Russia, the organization should have a code of conduct and internal regulations, and also agreements with the employees and contractors, a detailed list of information which is considered confidential, and a record of people who have access to such information. So these three types of measures should be taken seriously.
Thanks very much indeed. John, what do you have to say on this?
I would add one key aspect, Gordon. I think that you want to have a very, very tightly defined purpose within whatever agreement is governing the disclosure of that information to the JV partner or collaborator, such that they really can only use the information strictly in pursuance of that purpose. And then to echo what Yulia says, you need to limit the actual information you give just to that which is required to deliver on that purpose and nothing else.
Thanks very much. Chris?
I would add that you should assume that they will disclose the information, and you should act like it, whether they do it unintentionally or otherwise. So when you're dealing with others, you should only disclose what is absolutely necessary. And then when you do it with a view that you are creating an evidentiary record. So briefly, three things: you encrypt it, you stamp it confidential, and then you paper it with an NDA.
Thanks, Chris. Good, solid, and pithy advice. Celine?
Yes, I agree that with some partners, you need to take extra precaution, and it was my experience with universities or public research laboratories or departments. So I always recommend to clients to make a list, again, of concrete measures of what should be done to protect the information, but above all, what should not be done during meetings, for example. So these are the don'ts, and actually they can be very basic. Sometimes we forget about it, but They can be basic measures such as no open space meetings, for example, or no sheets left in the meeting room on the tables, or even erase whiteboards after leaving the room. So it's very basic, but it's very practical.
Thanks very much, Ivy.
Yes, I totally agree with Celine and Chris that it is significant to take concrete measures to protect the information. As my learned friends already have so much input for this question, the only point I would like to bring to your attention is that don't forget about applying confidentiality measures to our joint venture partners and affiliated companies. It's so common for the parent company and its affiliates to pass on trade secrets to each other. However, just don't neglect the fact that even joint venture or affiliated companies are recognized as independent and separate entities in law. Therefore, we still need to sign NDAs with affiliates and instruct our employees to take confidentiality measures when sharing or transferring information between them.
Thanks. Thanks very much. Anita.
Echo my colleagues. I think limiting disclosures, even in light of a solid NDA, is extremely important. But having said that, you can add certain provisions in your NDA, such as audit provisions or a significant remedy clause that may be helpful to discourage bad behavior or misuse of the information. However, what I would like to focus on is a special situation of research institutions, such as hospitals or universities, where the concept of a trade secret often conflicts with their academic obligations of public disclosure. So it's not the best place to keep a trade secret. So I think of universities as sort of the gossipy good friend, where they are more amenable to patenting. They're more used to it. Their systems are probably more in tune to and aligned with that, where they will generally agree to basic confidentiality provisions, but eventually the information will become public. So if the technology is really primarily best kept as a trade secret, then one solution I've seen is to have the information reside in a spin-off company, which has its own distinct space, servers, and policies. And a successful example of this was a 2018 transaction I was involved with, where the technology was a radiation therapy management software protected solely by trade secrets and no patents. And our client, Electa, was a major funder and collaborator. In that situation, the university or the hospital set up a separate spin-off company, Acumen, to house the technology and development of the software. And eventually our client bought the company in a multi-million-dollar deal. So it's definitely possible to make it work in the academic setting, but it does take some planning.
Thanks very much. I think we've got a bit of reverb on my voice. I'm not quite sure. I think it goes away after a while, but I hope that's okay. Another obvious hazard of the modern world is cloud-based storage of data. Now, this is the norm for major banks of data and information now. So just a very quick run from a couple of the panelists, from Chris and John. What particular steps might be needed in order to ensure proper protection when you put data in the cloud? Chris?
The fact is you can't guarantee that data in the cloud will remain confidential. And so if you have trade secrets of fundamental value, we have clients, for example, that have source code that is of almost infinite value. You simply don't store it in the cloud, and you don't transfer it via the cloud. What you do, if you must transfer it, you take other means. You might transfer it by secure file transfer protocols in some circumstances. But the fact is, we all live in a world where we have to transfer confidential information that may not meet that very high threshold, but is still confidential. Typically, we're going to use cloud-based services to do that. My team uses TitanFile all the time, which is a cloud-based transfer protocol, transfer software that uses its own security protocol to encrypt the data. So we all do it, but as a practical measure, one thing I can suggest is encrypt the data before you send it via whatever cloud-based service you're using. The cloud-based service will also encrypt it, but you should encrypt it first.
Thanks very much. John?
Chris has dealt with the some of the practical technical measures to keep that information confidential if you are storing in the cloud. The point I would make is that in order to establish the basis for asserting rights in trade secrets, you do have to set up the basic legal building blocks. The third element of which is being able to show that reasonable measures have been taken to maintain secrecy over that information. Now, lots of organizations will store in the cloud, although, as Chris says, some may keep their crown jewels somewhat closer. But the storage solution you choose must be objectively secure by industry standards, and you must be able to evidence it. You know, what security standards does the vendor adhere to? What due diligence have you done on the vendor? And what contractual measures and levers are in place for you to establish and maintain that information as secure as you can? And as long as reasonable steps and care are taken and you can evidence that, that, as I say, legal building block to establish trade secrets protection should be there for you.
Thanks very much indeed. Well, of course, no system is watertight. There are always those with the ingenuity and the bad motive to steal data. Sometimes it may be a departing and malcontent employee, or it could be a hacker from far away. Now, in a future webinar, we are going to demonstrate the pursuit of a criminal data thief around the world in a scenario-based look at the options for criminal enforcement and practical steps to pursue and stop a data thief. So for today, I just want to offer us a short teaser for that session by getting a brief global look at the criminal options available. So one at a time, panel, and keep it fairly brief if you can. What are the options in your country for criminal enforcement of trade secrets in the event of theft? Is this a criminal offence, and how well does the system work? Let's start in China. Ivy.
Thanks, Gordon. I'm going to set out briefly in 4 points. First, in China, acquiring trade secrets in the event of theft, inducement, threat, or other improper means shall constitute a criminal offence. And second, both of the natural persons and legal entities can be the subject of constituting the crime. It is worth mentioning that legal representatives or main persons in charge of these entities are capable of being indicted for criminal offences. Third, the criminal action shall be applied when the amount of loss is more than 500,000 RMB. The infringer then might be imposed with an imprisonment for up to 7 years, as well as a fine. Last but not least, a special injunction called employment prohibition may be applied too. The employment prohibition is not a kind of criminal penalty. It is a prohibitive measure to prevent the employee from committing the crime again. When the court makes such an order with a criminal sentence, the employee will be prohibited from engaging in relevant occupations from the date of completion of the sentence for a period of 3 to 5 years. Well, I have to say it is quite groundbreaking, and this was carried out by the court I used to work for. So in this actual case, the defendant was found guilty of infringing the trade secrets of his former employee and was then sentenced to 3 years imprisonment with 4 years probation. And he was then prohibited from engaging in the same occupation for 4 years.
Wow, that's indeed, now that is interesting. Yulia, what's the position in Moscow?
Theft and misuse of trade secrets is a criminal offense in Russia. A person who obtains a trade secret illegally by way of theft, bribery, or other means, or who illegally discloses or uses a trade secret acquired in the line of work may be prosecuted under the criminal code. Various fines and lengths of imprisonment are provided for, depending upon the proof of the theft or misuse. The most serious cases expose an accused to up to 7 years of imprisonment and fines of up to $20,000 or the salary of the offender for a period of up to 3 years. However, if the owner of the trade secret is not able to prove that the commercial secrecy regime was established, or the accused person proves that he got the information by mistake, he did not know or could not have known that the disclosed information constituted a trade secret, the court would dismiss the claim in the absence of corpus delicti. And this is for you, Gordon, to know that the language of Latin is not dead in Russia either.
Okay, excellent. Thanks very much. That's very encouraging to know. Thank you very much indeed. Celine, there have been European developments on this, so let's hear from you.
Yes, as you may know, we have had the European Directive on Trade Secrets in 2016, and this directive provides for the possibility for member states to impose criminal sanctions for the violation of trade secrets. So I guess that most of the member states have imposed criminal sanction. It was not the case in France when we implemented the directive, because we already had some criminal sanction of theft of paper and theft of digital data. So we did not need to new provision on that. So we use those to sanction violation of trade secret. It is really dissuasive under French law, because you can go up to 3 years imprisonment and to €1,100 as penalty. It's not that usually when you have an NDA, you go for contractual breach, but when you do not have any NDA, of course, you go for criminal sanction. What I would like to add just briefly is watch out the status of limitation under French law, of course, but I think it applies to all jurisdictions. For criminal offenses under French law, it is 6 years from the commission of the fact. So it's not that much, and you often realize misappropriation of trade secret several years after it was committed, and sometimes it's too late. And it happened to one of my clients that realized that employees left the company with entire folders containing trade secret, that the employees filed a patent, and then several years after, the employees opposed the patent to the client. And unfortunately, it was too late for the client to ask to get the trade secret back, because it was more than 6 years. So really be aware of that. When employee leaves, control everything, check everything, and protect your systems, as John and Chris just developed.
Thanks very much, Celine. John, UK.
Well, in the UK, trade secrets or information theft is not a criminal offence unless we are dealing with the theft of hard copy physical information, i.e. tangible property, in which case it may be covered by our criminal laws of theft. But that doesn't help us. I mean, we do in the UK have a fairly broadly framed criminal statute with regards to unauthorised access to computer systems, which is our Computer Misuse Act. Now, that actually has proved pretty useful as a criminal statute to deal with criminal hacking and theft. And it does have some teeth. I was involved in a case a couple of years ago, a civil proceeding, but there was an individual who was prosecuted under that act, and he was jailed for 32 months. So we do have some criminal protection.
Thanks very much, John. And finally to Chris, I think things are about to change in Canada.
They are, Gordon. It was the case that Canada followed the UK and that the theft of confidential information was not theft under the Canadian Criminal Code, period. We've always had a provision under the Security of Information Act, which dealt with espionage and state-to-state theft, but that's rarely used. But things are changing. In March of this year, Canada has implemented, at least by a royal assent, an implementation of the US-Mexico-Canada Free Trade Agreement, which will make it now a criminal offense to knowingly obtain a trade secret by deceit or falsehood. And then there is an imprisonment provision for up to 14 years for that theft. I would note, by the way, that reverse engineering does not fall within the provision, but this is quite a change in Canadian law.
And 14 years is a long time. That's a pretty heavy penalty. And presumably, Chris, much the same therefore applies in the US and Mexico.
Again, in the US and Mexico, it is based on those laws, or at least in the United States laws, I should say, that we are amending our laws to effectively conform. I would say that much.
Right. Well, there we have it. We know how to create a policy for trade secrets protection, how to draft a watertight NDA, what practical steps to secure data shared with a partner in the development of the invention, and an introduction to the range of criminal sanctions, which we will explore in more detail further ahead in this series. To close today, I'd like each of the panelists just to give us one tip from their own jurisdiction, which could be in any of the areas we've discussed or something we haven't yet covered. So what is the message they would like you to take away from this session? Panel, can you be pretty brief here? What is your message? Let's start with John.
Thanks, Gordon. I'd say one thing. If you want to enforce trade secrets, certainly in our courts, you have to be able to specify with real detail what your trade secret is. And you do that by way of a confidential schedule to your pleading. You have to be able to do that to get a case off the ground here. So you can't go into court just waving your arms around about trade secrets and expect to get very far. It won't work.
Thanks very much. That is very much to the point and very accurate. Celine.
For France, I would say that the European Directive really changed a lot. It's really important for the protection of trade secret now, and a trade secret is even more protected, I would say, than IPR. And I mean by that, for example, in the saisie contrefaçon, the very powerful tool that we have, now a claimant cannot have direct access to the document gathered during the saisie, during the infringement seizure. The documents will be seized by and kept by the bailiff, further to a disclosure by the judge himself. So it's quite new for us, and this is thanks to the directive. So much more protection for trade secrets. And I was told by our partner in Germany, Manuela Finger, that's the same in Germany. The Trade Secret Directive really changed German law, and it reinforced protection of trade secret there.
Thanks very much, and thanks for the German tip-off as well. Julia from Moscow.
So I would say briefly that being specific about what is protected as a trade secret is very important, and also being able to show that the reasonably necessary measures has been taken, which is a prerequisite to successful enforcement of the trade secret rights in Russia.
Thanks very much indeed. Ivy.
In China, I just want to assure you that it is definitely actionable to enforce your right of trade secrets here. And just don't forget to improve the management of trade secrets inside the company and prepare for quick response mechanism in case the trade secrets get out.
Thanks very much, Ivy, and I can vouch for that. I've been involved in successful actions in China for trade secret enforcement. Please don't think you can't do it there. Chris, finally.
I would say get ready to dig in. Trade secret litigation is antagonistic in its own unique way. These are allegations of theft, and that leads to an early positional entrenchment in a way that I find patent litigation does not. So if patent litigation, the way I look at it, can be like a fencing duel. You have objective claims that everybody can see, and it gives it some element of objectivity. Trade secrets, in my experience, are hard fought. They're closer to barroom brawls with all the confusion that entails.
Thanks very much indeed, Chris. So we now just have time to consider a couple of questions. There have been a lot of questions, and for that, many thanks to the attendees today. What we will do, we won't be able to answer all of those questions now, but we are going to follow up with a note which pulls together the key threads, and we will attempt to answer some of the questions in there. But can I just pick out a couple of questions to ask here? So, for example, to John, we've heard mention quite a bit about the EU Trade Secrets Directive. Given Brexit, does that have any relevance to the UK going forward?
Oh, okay. Well, actually, the UK did implement parts of the Trade Secret Directive a couple of years ago. A lot of people didn't think there was any need to, because our law is very complete on confidential information, but nevertheless, certain elements of it were implemented. So we do have parts of it in our law, most critically of which I think is that definition of trade secrets that sits within that directive, which I think everybody accepts is a very good description of confidential information. So yeah.
Thanks very much. Question for you, Anita. We've talked, there have been a few of the speakers today have talked about the term of an agreement, and you know, the fact that it can actually be quite damaging if you've got a very short term in persuading the court that that the information is really confidential. But is there an upper limit on the term of the duty of confidentiality in an agreement?
Very good question, and it's one of the provisions that we often look at. No, I mean, in Canada, you can actually have it until the confidential information is no longer confidential. That might vary from jurisdiction to jurisdiction, but definitely that would be the starting point. But many companies and many NDAs, depending on the nature of the information, want to limit that term because of just their own internal processes and systems. So, but definitely if it's important information,
okay,
have it until confidentiality ceases.
Thanks very much, Anita. Finally, last question, and we deal with them to Celine. Under French law, we've heard you've talked about the impact on the saisie contrefaçon of the European Directive. Is it possible to request provisional measures to the preliminary judge in cases of breach of trade secrets? And if so, what might those measures be?
Indeed, it's possible. It's always possible to go and see the preliminary judge, and under the French transposition of trade secret, there are some specific provisions that allows you to go and to obtain an injunction to forbid the use of the trade secret, to forbid the marketing of the product. You can also obtain the recall of the product that were made from your trade secrets, the destruction, and you can also obtain damages if of course the claim is really clear cut. And once again, the necessity to have all the evidence in amont. So yes, you can, and you can obtain a decision within about 3 months. Several weeks is it's really urgent, and 3 months is an average.
Thanks very much, Celine. And so apologies again to those of you who haven't had your questions answered, but we will endeavour to get some answers out to you with the summary of the webinar. So many thanks indeed to the panel. Thank you very much indeed for your time and for your contribution today. And thank you to everyone who has attended this event. We really appreciate your interest, and I hope we've been able to enhance your knowledge and understanding of the world of trade secrets. My own takeaway message is this: you should treat trade secrets just as you should treat any other intellectual property right. Yes, it is even more intangible than the other rights. There's no nice certificate to show that you own something, but a trade secret is a piece of property to be catalogued, guarded and enforced just as much as other IP rights. It is not a poor relation. It can be your best option, and it can be incredibly valuable. Of course, it's not had the benefit of global legal harmonization in the way that patent law has evolved internationally. But I think another of today's messages is that the sophistication and consistency of trade secrets protection is developing across the globe as more and more countries recognize the economic importance of this key IP right. So looking ahead for the next 2 webinars in the series, we're returning to the world of patents. We will be looking at international patenting strategy and drafting techniques in the separate events dedicated to life sciences and tech and engineering respectively. So look out for the invitations for these events, which will be coming out shortly. In the meantime, a recording of this event will be appearing at goexcel.gowlingwlg.com very shortly if you would like to watch again, or indeed to share with any of your colleagues. So thank you once again for your very kind attention today, and we look forward to seeing you soon at one of the next webinars in this series. This broadcast is now going to close automatically in just a few moments. Thank you very much indeed.